Hello and welcome back to Coin Lady channel. The realization that there is a fundamental problem in the world is what really hit us and why we decided to invest heavily in the blockchain movement. Which side do you anticipate winning in the court case pitting the US Securities and Exchange Commission against Ripple? It's no secret that different experts have different theories for how this case will end, with some favoring the Ripple theory. Developments in the case suggest we can anticipate. There was talk a few days ago that Ripple Labs Inc., the American IT firm that constructs XRP infrastructure, would be close to reaching a settlement with the SEC. Notably, a few days before this story became viral, Judge Annalisa Torres allegedly ordered the governing agency to unseal documents involving former SEC functionary William Hinman. Numerous well-known crypto attorneys shared their thoughts on the topic. According to Fred Rispoli, the decision to unseal Hinman's emails is a significant step in finalizing the summary judgment ruling. In agreement with Rispoli, Jeremy Hogan pointed out that the wording of the orders gives the impression that a sizable chunk of the order on summary judgment may already be drafted. Mark Veghel, an expert in government security enforcement, agrees with his judgment and thinks it's fair. Rejected by Judge Annalisa Torres of the Southern District of New York. The SEC previously attempted to censor Hinman's speech explaining why he does not regard Bitcoin and Ether to be securities. In 2020, 3 times, the SEC's plea for the judge to let Sarah Netburn was denied by the judge presiding over the case. Judge Netburn says so. Motivations behind these requests were contradictory and ran counter to the spirit of the legislation. She claimed that the SEC is using litigation as a means to an end rather than as an expression of a sincere commitment to the law. When the SEC first tried to prevent the use of Hinman's remarks, they claimed that they did not represent the views of the securities regulator but rather those of Hinman alone. Documents are about and why the SEC is so concerned about keeping them secret was denied. The Hinman papers are related to a lecture given by former SEC Director William Hinman in 2018. Regarded as security due to its decentralized structure. Current offers and sales of Ether are not securities transactions, in my opinion, due to the decentralized nature of the Ethereum network and Ether's current form. This speech was crucial because it suggested to the crypto community that digital currencies may evolve from securities to commodities once they became sufficiently decentralized. If Judge Annalisa Torres decides that Ripple did, in fact, sell unregistered securities, this may affect Ripple's fair notice defense. The discovery documents were produced in the second half of 2022 at Ripple's request. Instances that the records are relevant to the court's summary judgment determination, even though they may be utilized as part of the Ripple's defense. Since they had already tried and failed to conceal the papers, this is hardly a surprise. In her judgment dated January 13, 2022, Judge Torres refused the SEC's next similar request, which was made just days earlier. Since the Hinman speech materials are not related to a position decision or agency policy, the deliberative process privilege does not apply to them. Judge Torres ruled that sealing these papers had nothing to do with maintaining transparency and integrity within the agency. The judge ruled that regardless of whether or not the document would be admissible in court, it should be made available to the public in accordance with the common law norm of public access to judicial papers. Papers are those that are both necessary for the judicial process and important to its execution. Judge Torres ruled that a piece of evidence is relevant regardless of how the court rules or whether it actually sways the outcome. She clarified that the more relevant question is whether or not the material in question is likely to sway a district court's decision on a motion. Praising the judge for her dedication to transparency and promising that the documents will be made public as soon as possible after the lawyers for Ripple were given permission to do so. Another victory for openness. Garland House's recent tweet about the release of unedited Hinman emails. Thankfully, it'll be on the market very shortly. Follow along as the attorneys figure out how to make that happen. For that purpose. But it's too soon to celebrate. Although Ripple has overcome yet another obstacle, it's crucial to remember that this case has been going on for years and is far from over. But please don't misunderstand. You and I are both eager for this matter to finally be resolved. In the meantime, Ripple too attempted to redact a number of documents, including contracts, financial records, and more. The court agreed with Ripple's contention that the requested redactions are focused and specific, and she's allowing many of them to go through, including redactions related to the company's financial accounts and certain corporate information. The judge ruled that other proposed redactions, including many suggestions related to XRP, are overbroad. Even if it's too soon to say what the final conclusion of the lawsuit will be, what does the latest verdict indicate for the case? Rejected other applications to seal from Ripple, including statements connecting Ripple's income with XRP sales and the amount of compensation paid to trade platforms. Following the judge's decision on what can and cannot be sealed, such as the Hinman emails, pro-XRP attorney John Deaton tweeted that many people are discussing a split decision in which Ripple is tagged for early XRP sales but oddball and secondary market sales are found to be non-securities DT. The judge agrees with Ripple. The jury will have to decide whether or not those early sales should be excused because Ripple was not aware of the securities laws at the time. But he also said that he doesn't think Ripple has a chance at a total triumph anymore. He tweeted in the same thread, "After reading this, I no longer believe that Ripple has a chance of an outright victory. I'm still not convinced that the SEC is winning this." And speculated that the courts would find Ripple liable for XRP sales associated with the ICO and other transactions meant to promote the network's growth, but that XRP sales on the secondary market and the coin itself are not securities. Former SEC securities lawyer Mark Vegel weighed in on Twitter, lending credence to Deaton's views on the matter by saying he mostly agreed with them but that the SEC suit was worded in a way that focused on the tokens issued by Ripple rather than secondary market transactions. Too far in ruling on secondary sales, he found them useful in the SEC use case because they showed how the emergence of a secondary market was made possible by Ripple issuing securities and marketing the network. So, when can we expect a final ruling on this matter? In a recent Twitter discussion, noted pro-crypto lawyer Fred Rispoli stated that the summary judgment is already written and might be published any day now. He also agreed that a split decision was the most likely answer. In a tweet he wrote, "Very hot day. For some time now, everyone has been promising that the SGA ruling will be released any day now, and the time has finally come." On the other hand, Deaton stated during the Twitter space that he thinks Judge Torres knows how she would decide, but that speculating on how much is written in its final form would be foolish. The attorney for pro-XRP agreed that a ruling may be issued at any time, but he cautioned that it could be a month or more before anything was finalized. Do you have any thoughts? When do you think we'll be able to take a deep breath? What kind of breath you take after hearing the judge's decision, one of relief or exasperation? Don't miss out on the latest information. Please hit that like button and turn on your notifications. See you in the next video. Bye.